Hello and welcome to Organized, the Business Law Breakdown. I'm Professor Seth C. Orenberg, and today we're discussing fiduciary duties and partnerships. Fiduciary duties are foundational to trust and cooperation, which make partnerships work. Fiduciary duties ensure that partners act in the best interest of the partnership and each other, and this provides accountability while allowing the business to thrive. In this lecture, we'll examine the core fiduciary duties under the Revised Uniform Partnership Act. We'll explore some real-world examples of fiduciary duties, and we'll consider the practical challenges of balancing fiduciary obligations with personal autonomy. The duty of loyalty is perhaps the most central obligation in any partnership. Under Revised Uniform Partnership Act, Section 404, the duty of loyalty requires a partner to refrain from engaging in activities that conflict with the interest of the partnership. Specifically, partners must account for any profits or benefits they derive from the partnership's business or property. They must avoid competing with the partnership while it is ongoing, and they must refrain from acting on behalf of parties adverse to the partnership. These are what we refer to as the duties of loyalty. To make it more concrete, imagine a partner in a real estate development partnership secures a lucrative opportunity to purchase land. If that opportunity arose because of the partner's role in the partnership, they are obligated to disclose it to the partnership and allow the partnership to pursue it before they take or usurp that partnership opportunity. Failing to share this opportunity with the partnership would constitute a breach of the duty of loyalty. The duty ensures that partners prioritize the partnership's interests over their own personal gain. And again, this fosters trust and collaboration. The duty of care, which is also outlined in Revised Uniform Partnership Act, Section 404, requires partners to avoid grossly negligent or reckless conduct. They're also prohibited from intentional misconduct or knowingly violating the law. While the duty of loyalty imposes proactive obligations in the partnership's best interest, the duty of care is really more about avoiding harm. Consider a scenario where a partner in a manufacturing partnership approves the purchase of faulty machinery without conducting due diligence, like without inspecting the machines, as is reasonable to do. If the machinery causes significant losses, the partner's failure to exercise reasonable care could be deemed a breach of the duty of care, and that might make the partner liable to the partnership. Unlike the duty of loyalty, which demands active allegiance, the duty of care imposes a standard of competence and diligence in decision-making and action. In addition to the duties of loyalty and care, the Revised Uniform Partnership Act imposes an overarching obligation of good faith and fair dealing. This means that partners must act honestly and fairly toward one another and the partnership. While it's not an independent fiduciary duty, this obligation infuses the duty of loyalty and care with an ethical baseline. Let's make that a little more concrete with an example. If a partner negotiates a contract on behalf of the partnership, they must disclose all material facts and ensure the terms are fair to the partnership. Acting in bad faith, such as withholding crucial information to gain an eventual advantage over the partnership, would violate this obligation. The good faith requirement serves as a reminder that partnerships are built on mutual trust and respect, and that ethical conduct is essential to their success. Fiduciary duties are designed to protect the partnership, but they can create tension by limiting a partner's freedom to act independently. As was mentioned early on in the season, becoming a partner, even inadvertently, creates obligations that one might not intend, that limits actions one might otherwise take. For example, the duty of loyalty might prevent a partner from pursuing personal business opportunities, at least when they overlap with the partnership's interests. Similarly, the duty of care can expose the partner to liability for decisions made in good faith, but with poor outcomes. Modern partnership law recognizes these challenges and provides mechanisms to balance fiduciary duties with partner autonomy. The Revised Uniform Partnership Act allows partners to define and modify their duties through their partnership agreement, provided they can't completely eliminate the duties of loyalty and care. If they want to eliminate those duties, another form, like a limited liability company, might be more appropriate. But partners might agree that certain business opportunities are not subject to the duty of loyalty, or that specific actions are exempt from the duty of care. These agreements, which again would need to be memorialized, typically in a partnership agreement, which should be written and written by lawyers, allow partners to tailor their obligations to the unique needs of the partnership. And so, when fiduciary duties are breached, the partnership or other partners may take legal action to seek remedies. Common remedies include disgorgement of profits, damages for losses, or even expulsion of the offending partner. Courts often look to the partnership agreement as well as the specific facts of the case to determine whether a duty was breached and what remedies are appropriate. In conclusion, fiduciary duties are the backbone of partnership governance. Fiduciary duties ensure trust and accountability while allowing the business to function effectively. The duties of loyalty, care, and good faith are essential to balancing the collective interest of the partnership with the individual interests of its partners. As you reflect on today's lecture, you might consider how fiduciary duties shape behavior. If you were in a partnership, how would knowing these fiduciary duties change what you do and don't do? How might you balance obligations with the need for flexibility and autonomy? How does the existence of these fiduciary duties as a matter of default law impact the need to have written partnership agreements? Thanks for thinking through these issues with me. As always, this has been Organized, the Business Law Breakdown, and I'm Professor Seth C. Orenberg. In our next lecture, we'll explore disassociation and dissolution in partnerships. I'll see you next time.